Good evening, friends. I welcome all the participants and all the panelists for this 44th webinar of Corporate Professional and third question answer session on company law. Friends, as you are aware that we are trying our best to bring best topic and the best speaker to explain the nitty-gritty of the subjects and relevant questions which the experts are giving answer. I thank all the 1064 participants, those who have registered, and the participants, those who are participating, because registered participant and the active participants, these are the two different things. But today we got a 1064 registration. And I'm happy that till now we got total registration where the people have participated in various programs is more than 25,000. And that is the thanks to all participants, those who are showing their interest and they are participating in big numbers. Friends, purpose of these program is to educate the corporate India professionals on new subjects, new topics, and whatever new amendments are coming and whatever new law they are proposing, we want to discuss threadbare with the help of experts and with the help of regulator. But this question answer program is unique. Here what we are doing, whenever there is a new law and the new amendment is coming, there are so many interpretation, multiple understanding, and we want to remove the doubts and we want to give a clear understanding of the subjects. That's why we want to invite the best people. These panelists are jewels in India, in our country on these subjects. They are expert, they are doing day and night work. They include the working in a big companies, practicing in the court, practicing as a company secretary, and they are working up. Today we have invited the various people, those who are expert on their subjects, because all these people, everybody well known. So I'll not take much time, but for the sake of explaining that who they are and what they are, they will talk. My first speaker is Geetika Anand. She is Vice President and Company Secretary and Compliance Officer, Adit Birla Fashion and Retail Limited, Adit Birla Group. Acquisition. She was a part of core group vision ICSI 2022 and she was a member of Secretarial Standard Board, and she is the one of the budding professional for future. I welcome Geetika. Then Amit will join just now. He is in a board meeting. Just now he's joining. He is a member of NIRC. He is a member of Audit Standing Committee since inception. He was a member of Secretarial Standard Board, and I in the ICIC New Vision 2020. He is a FCS, insolvency professional, and various other courses he has done. I welcome Amit in your absence. Then we have Mr. GP Madan, who is a managing partner of Madan Law Office, advocate and solicitor, Vice President, Insolvency Practice Bar Association, registered insolvency professional, managing committee member of PhD Chamber of Commerce, co-chairman of IBC Committee of PhD, co-chairman of M&A Task Force of SOCHM. He is a regular speaker, giving training to the various people, and he has 35 years experience, and he was also member of Secretarial Standard Board. I welcome Madan for this program. Then we have Savitri Parikh. She will also join. She is in one program, so she will come. She has a 25 years experience. Reliance Industry, Joint Company Secretary. She has authored various company law book and specialist auditor or editor of Ramaiah Guidance. She is the chairperson of the Corporate Governance Committee of Bombay Chamber. She was also member of Secretarial Standard Board and Vision Committee. She has received so many honors and awards. We welcome Savitri Parikh for this program. Then we have a K.S. Ravichandran, who is a practicing company secretary, MCom FCS LLB PhD, managing partner of KSR and Company. He has been a 25 years experience, practical experience of NCLT, NCLT trademark, intellectual property right, DRT, appellate tribunal, tribunal, and various other places he has done. He's also a prolific speaker and writer. He has written so many books. He is independent. He is on the board of Kayur Vaishya Bank, and he's a co-chairman of Karnataka Council of SOCHM and Corporate Affairs Council of Bangalore Chamber of Industry. We welcome Ravichandran. Then we have Narayan Shankar. He's a company secretary, commerce and law graduate. Presently, he is the compliance officer, company secretary, and executive vice president of Mahindra & Mahindra. He's on the board of several companies. He is a member of Securities Standard Board of ICSI. He is a member of expert group of reviewing SEBI shares-based employee benefit regulation and SEBI issue of share equity regulation presently, which is working on this. I welcome Narayan for this program. Then we have a Ankit Singhi, who is a company secretary, and he's written various books. He is a practicing company secretary and working various companies. He is a prolific speaker and writer, and he's like Geetika, he's also budding practicing professional for the country. I welcome Ankit. Then we have Sudhakar. Sudhakar is a qualified company secretary and he's a chartered accountant also. He's a vice president corporate and secretary, chairman of Securities Standard Board since and then member since 2016. He was also member of Business Committee, Institute of Company Secretary. He has a very vast exposure and experience on various facets of corporate and security law and is a sought after speaker for various programs. So I welcome Sudhakar for this program. Friends, today's program structure is very simple. After this introduction, we will start. We have received various questions and we will start questions on the topic wise. In the meantime, you all can send your questions. I think a few questions are already you can give it to us. Please don't send questions which are not relevant today or which is not relevant for today's topic. If time permits, we will try to answer if you are sending. Otherwise, I'll request you stick to your topics which we have given. So today we will discuss threadbare all points related to amendment and definition of listed company, applicability of certain provision of Companies Act of to LLP, adjudication of penalties, compounding of offense, is recent amendment in CSR, dividend and IPF, and deposits. So you have any questions, you can refer to us and we can start. So now start with Geetika. Geetika, the amendment in the definition of listed company has taken place. So what is your immediate view on this? Why the government has done this, and what are the advantages for the corporate, and how we can take advantage and understand the subject? Geetika, to you first. Please unmute yourself.
Sorry. Good afternoon, everyone. So taking forward the point that you just said, to set a little history of this amendment is while it came now, we believe there was a representation by the smaller group of entities which had not listed their equity shares to MCA about in 2016, which was then reviewed. However, on various multiple representations, they took note of it. And in the 2019 committee report, they had mentioned that in terms of ease of governance and ease of business, they can consider removing these from the Companies Act to ensure that the compliance burden on these entities which do not have their equity listed reduces. I believe when this was consulted with SEBI, it was clarified that under listing regulations, the uncommon chapter, which is relating to governance provisions, is already not applicable to these entities. And therefore, it was easier to amend the definition in the Companies Act and thereby ease compliance for them. While that is the background, my immediate thought process was to go and search as to actually how much burden does get reduced. And when you search, you will find listed company in about 22 places under the Companies Act. And you will realize the real burden is where one has to make committees, form committees, and that entire burden goes off from for these small companies. In addition to that, there are smaller things like when you are getting your scheme, a merger scheme or a compromise scheme, you get off sending it to the stock exchanges and SEBI unless SEBI requires it under the SEBI listing regulations. And obviously, smaller compliances, for example, Section 93, where you're supposed to give a change in promoters' holding. Now, that was a section which is only for listed entities, and therefore they get out of those provisions. So, net, one can say that secretarial audit, a major provision which was under Section 197(12), where the CFO, the board of directors, had to specifically mention for all listed companies about internal financial controls. So I think these are the provisions which help them in reducing their administrative time as well as governance framework for entities without equity listing. That's the large crux.
Okay, Narayan, you want to add something on this particular law which has come?
No, she's covered it very well. I don't think anything more. I think everything what she has made a mention. In fact, there are various places in the Companies Act also where listed entities term is also done. But I think she's covered it very well.
Okay, Sudhakar, you are working in Reliance and you have multiple private companies, multiple subsidiaries, and multiple instruments are listed also. So what you see that this particular amendment will help corporates?
Yeah, see, good afternoon, all the participants. And at the outset, let me put a disclaimer that whatever the views I'm expressing, these are all my personal views. Nothing belongs to the organization in which I'm employed. And also, I convey my sincere thanks to corporate professionals and Mr. Pawan Vijay for giving me an opportunity for the 6th time to participate in these webinars, the 44 webinars of corporate professionals. It's an excellent achievement of corporate professionals for continuously organizing these seminars. Having said that, now as far as the question is concerned, yes, it's a great help to the industry because we do have some private limited companies whose debentures were privately placed and listed with the stock exchanges. And because of that, technically under the Companies Act, they were listed companies and they were to comply with all the provisions pertaining to the listed companies like appointment of independent directors, audit committee, women directors, whatnot and all. So by that, it was absolutely not warranted as such because it's completely purely a private limited company. Just its debt securities are listed in the stock exchanges. So for all purposes, it is treated as a listed company under the Companies Act. So this is a great relief as far as the corporate is concerned, that especially the closely held public companies and private limited companies who has issued non-convertible debt securities or non-convertible preference shares in case of public, unlisted public companies. This is a great relief as far as I'm concerned. In fact, we did got advantage because of this.
Okay. Ankit, you are doing audits of various companies. What is your feedback from the corporate?
I think this was a much needed relief. That was the case. And as mentioned by Sudhakar sir, private companies where only debt securities were listed were being forced to have independent directors, and which really doesn't make much sense. So it is definitely a welcome step. It was supposed to be taken much earlier, but has find the light of the day.
Okay. If the
Madan sir has something to add.
Yeah, Madan.
First of all, I echo the views of Sudhakar regarding corporate professionals and Mr. Pawan Vijay. Secondly, as Mr. Pawan Vijay said in the beginning, that all the who are present here, they are jewels and experts, barring me. I consider myself a practitioner of law and a student of law, and I'm still learning something. Now, last week, I was addressing a gathering of directors and independent directors. They were 43 in number. And on this issue of listed company, I tell you, not even a single director, and at least 15 of those were from listed companies. Not even a single director knew the meaning of the term listed company. Not even a single knew the distinction between listed company and listed entity. I think the earlier provisions were really harsh on some private companies whose these debt instruments or particularly non-convertible instruments were listed on the exchange. And as Ankit said, it is a much sought after relief to these companies. And if you ask me, I would like to have more relief for these companies as far as the listed companies are concerned. Because certainly the moment you say listed company and then the provisions of Companies Act with respect to listed companies are applicable to these companies, that's really too much. This is my personal view. Secondly, I would like to have a clarification from all of you also regarding this amendment, which has been introduced through 2AC. If you are having a copy of this amendment with you, 2A says the following class of companies shall not be considered as listed companies. And then the C says, I'm just reading it, public companies which have not listed their equity shares on a recognized stock exchange, but whose equity shares are listed on a stock exchange in a jurisdiction as specified in subsection 3 of section 23 of the Act. Actually, in my book, I could not find subsection 3. Either I am having an obsolete book or there is some drafting error here in the notification. There is no 23.3.
Sir, while this is intended to cover the proposed amendment of allowing unlisted public companies to get their share listed abroad.
No, but
the relevant provision, I think, is still missing. I think so.
I couldn't find it in the book. I think there's some clarification.
Sir,
amendment clarification, amendment to the notification is also required. And if you talk,
ministry is foreseeing the future, na? So it is in the pipeline. It is about to come.
I'm not in agreement with this. Number two, if you're talking about foreign jurisdiction, foreign exchanges, I have gone through the definition of the stock exchange, the recognized stock exchange in SCRA also. And there also, I do not find any stock exchange within foreign jurisdiction has been recognized in SCRA. That is what my understanding is. I think because of this, as far as C is concerned, it has created more confusion rather than providing some clarification.
Okay, what Madan sir, we will do, the certain points which are not clear or which require some interpretational things which we expert are not able to give answer, we will ask ministry to give a clarification. So well taken your point which you are saying. Geetika, the point is, what would be the impact on the companies which cease to be listed company now? Because earlier our company were listed and now they are not listed. Do SEBI regulation for this particular chapter will cease to be apply on company? Number one. If yes, how would be assuring that this SEBI regulation would have impact on the company?
If you don't mind, I'll just continue answering the point that Madanji said. I feel it's not an anomaly in the law, and that is not what he's trying to highlight as well. It is something which is yet to be prescribed. And I think there are various amendments which come about where prescriptions are yet to be made. For example, take CSR law form, CSR 1 is yet to be prescribed. So I think it falls under that bucket as to maybe prescribe. And therefore, one can wait for it and as well write and make a representation. Coming to the point that you just highlighted, so as I said in the opening remarks, what has come out for these entities which have listed NCPs or preference shares are the governance provisions. Governance provisions were never regulated by SEBI in the first place because Chapter 4 was not applicable to them. So by virtue of it going out from the Companies Act, the impact on these committees are that if they had specifically constituted certain committees under the law, in a certain time frame, if they want to dissolve those committees, they'll be fine. It will not be considered as a non-compliance after official publication in the Gazette. If they do not have those committees or they do not have specified number of directors or compliance under those relevant sections. So I think that's the impact of this completely taking off the burden in one.
Okay.
I answered the point.
Sudha, if company issued listed convertible debenture on private placement basis, will it be treated as listed company? Because they are saying non-convertible.
Yes, correct. Any convertible security, if it is issued Under the listing regulations, it follows the definition of specified securities, and Chapter 4 regulations are equally applicable to that company. And as far as this exemption is concerned under the Companies Act, it has been given only to those companies who have issued that non-convertible securities. Hence, if any company is issuing any convertible security, there is no change as far as the Companies Act is concerned.
Okay.
And as far as listing regulations are concerned, what the regulations were there earlier, they are also now the same regulations are there.
Okay. So that
Just
Sir,
to
I can
clarify,
take that
Madam.
point forward. Ankit, just a minute. If I can
Yeah.
take that point forward. Suppose I am a private company. I do not have anything listed as of date, not even NCDs, not a preference share, and I decide to have listed CCDs. What would be my date of listing in terms of Companies Act and listing regulations? Will it be the day I issue CCDs, or will it be the date of conversion?
Geetika, you have asked this further question. My one question which I am asking Sudhakar. Sudhakar, you are saying public companies convertible instrument will cover listed definition. Okay. But what about the private company? If there is a private company which has issued convertible instrument and that is listed, will the private company be identified?
A private company, according to me, a private company cannot issue convertible securities to the public, because that is there not there in the fundamentals of private companies. It cannot
Yes.
issue any securities to the public. It can issue the debt securities, but not the convertible securities.
Okay. Any other different view?
No, I think, sir, it's a.
If that being the so,
Sir, just to clarify, Madan sir, you will find the answer of your question in the Amendment Act 2020.
I got the answer in Q&A section also.
So Amendment Act 2020, sir, they have amended Section 23 with respect to
that is like I gave a disclaimer that my book may be older one. I said
so
that.
if you refer that amendment, you will find the answer there.
And can you believe it? I went through one of the website also, app also, not all comprising.in, but some other app, even that was not also updated today.
Because it's still not notified. That's maybe the reason.
But still, anyway, some reference should be there. Now, taking a cue from Mr. Sudhakar, then I'm of the view, why not to exclude private companies from the definition of the listed company? They can't issue convertible. If they issue non-convertible, then they'll not be called, and they'll get them listed, and they'll be unlisted companies. Then why not to exclude private companies as a whole from the definition of listed
I
company?
think this point
Makes sense.
this point can be given to the ministry that you have in the new Companies Act, they have removed all word. The company mean all company. Exception they are giving at the in the previous proviso. So it is better that in this case they can explain properly that private companies are not covered. Okay. So now I'll go to the next portion, applicability of certain provision of Companies Act LLP. Now these are questions which I have received. Some of the questions are coming, so I will cover that also if there's any listed company question. Now, currently, which section of Companies Act 2013 are applicable to LLP, Ankit?
Section 458 and 460.
Okay.
But there is also confusion under the erstwhile Companies Act. The entire winding up provisions were also applicable on the LLPs. There was a notification, but post commencement of the Companies Act 2013, there is no such notification that new provisions of Companies Act 2013 will apply on them. So under the new act, only two section notifications have been issued for 458 and 460.
Okay. Amit, we are seeing your face after so many days. You
He
have.
looks very cute. He looks very cute.
Where is Amit? Amit is there?
Okay. Amit, whether the certain section of Act 2013 which are mentioned in the message of NCA 21 portal has been applicable to LLP? If yes, what is the date of enforcement?
Sir, as of now, they are not applicable. As Ankit was mentioning, only 458 and 60 are applicable as on date. But government is intending, we were having a discussion with Sudhakar sir last week in some other forum, So what my understanding is, government is slowly and gradually converging the applicability of provisions of Companies Act to the limited liability partnership. The era which limited liability partnership was enjoying up till now of freedom is going to be over. They would be having the similar restrictions what are there in the companies. Sooner or later, gradually they are moving, like disqualification and vacation, number of directorship, all these things are going to be there. And as Ankit was also highlighting regarding the provisions of winding up, so government is contemplating the extension of the provisions of the Companies Act, for which the separate provision is not there in the limited liability. Those provisions will also be extended. So all these as on date are only provisions.
Okay.
And I think, sir, one of the significant reason for such a consideration is what I had a word with some MCO officials is with respect to the increasing malpractices in the structure itself.
Correct.
Which is which the ministry is trying to curb in the companies, but that is now moving from companies to the LLP structure. So though they want to curb that malpractice here too.
Lot of SEBI reports have been there where the indication of web of transactions have been highlighted with regard to the misuse of these entities towards attaining the goals what they wanted. So I think government is now trying to regulate these entities as well.
Sudha, after enforcement of provision of a SBO on LLP, who will give declaration of SBO to LLP?
That in fact, that itself is a very significant step, as far as the applicability of Section 90 to the LLPs. That idea itself is, in fact, very curious according to me, because even under the garb of LLPs also, several activities might be going on, and basically that is the intention of MCA to make it applicable to LLPs. Now, question comes, who will give it? Number one, we have to wait for the provisions as well as the rules to be, framed. Number one. Number two, according to me, most probably whoever our partners are there, they may again prescribe some kind of percentage of the partnership ratios, whatever it is having it. They may have to declare themselves. And I don't even wonder if MCA is going to ask each and every partner to declare that himself as SBO and a significant beneficial owner, and also give whatever the disclosures they have to give.
Okay.
But Sudhakar sir, will this also trigger changes under Section 90 per se for companies if they change the manner of ascertainment of SBOs in case of LLPs, where they are partners in the members in companies?
See, according to me, Ankit, according to me, Section 90, as far as the companies are concerned, I don't think they are going to touch any provisions. Only thing is, they may be adding some more things. See, that Companies Act, they are not going to touch. What they say is basically Section 90 related provisions, means what SBO related provisions, they may be incorporating in the LLP Act as such.
No. So
because
my question is,
as such is not going to applicable to the LLPs. Companies Act is not going to applicable to LLPs.
No. My question is, the Companies Act prescribes that where LLP is a member, the SBO will be ascertained in a particular manner. So will they extend the same formula there also? Because if they change that formula, that will imply a consequent change to the company's formula also. Because who would be the significant beneficial owner for LLP will also be the beneficial.
According to me, most probably the essence MCA may keep the same, both for companies and LLPs, because objective is the same. Only thing is that the rigor may be different and the rules may be different. Amit was on top, wants to add something.
Amit, you want to add something?
Yeah, I'm saying just to answer to the question what Ankit was trying to pose. See, to my mind, even if it is applied to limited liability partnership, Section 90 per se is not required to be amended. And especially with regard to the recognition of SBOs with regard to the LLPs. See, the principle would remain same. If your partner is a company, you will follow the same principle what you get in Section 90. There is no change as such.
Okay.
So I'm only saying the same principle would continue to apply in
case of LLPs too.
Correct.
Yeah, it is already there.
Yes.
And moreover, if the government wants to do something with the act, it's not possible to amend the act. Government does something with the rules. If something is not possible is to be done with the rules, the government does something with the forms, and all those amendments and the intention of the government is carried out.
Okay.
Sir, you know them very well.
Ankit, after enforcement certain section of the act, how to calculate number of LLPs or number of designated partnership in LLP as per section 165?
Sir, that will depend finally because if we have to read the message very carefully, it says that it will be applicable subject to necessary modification and amendments. So while prescribing the applicability on the LLPs, the government will also outline the manner in which it will be applicable, and it can only be made applicable to a designated partner, because I don't think government can restrict a individual's ability to become partners in a number of firms. That is a fundamental right to do business. I think they can only restrict the right to take the position of designated partners in some firms, because that under the act he is responsible for the compliance of the provisions of the LLP Act.
Okay. Amit, after enforcement of section 252 of LLP, to which authority oblique partner oblique designated partner can file the application for restoration of LLP name?
Sir, it would be definitely a National Company Law Tribunal as is prescribed under section 252 for the companies. And even if I can share you a couple of orders, I am having a privy to Chennai bench and Karnataka bench NCLT order where the restoration has already been done. So it's because of the principle of the natural justice, because no law is applicable as on date. So court has taken the cognizance on its own, applying the principles of 252, they have restored the LLP. So I think it would be the same National Company Law Tribunal which would be doing so.
Okay. So now this is these are some questions, question which we are receiving. I will cover again. So I'm coming to the adjudication of penalties compounding on offense. Okay. So anyone can explain, Amit or Ankit, do you want to explain something about this, what they have modified?
I think the modification is with respect to the entire mechanism, how government will prosecute non-compliances. So while on one hand, there is a mechanism of compounding, where in offenses which are punishable with fine, you can go and get the offense compound from the NCLT or the RD as the case may be. In lot of offenses which was earlier punishable with fine, now they have substituted the word fine with penalty. And they have created an in-house adjudication mechanism where the ROCs have been empowered to adjudicate the non-compliances where the penal provisions involves levying any kind of penal penalty, and they can adjudicate and issue the show cause notice to the defaulting companies asking for the reasons of non-compliance and take a final call on levying the penalty that has the act. So this is called as an in-house adjudication mechanism where the registrars have been empowered, and the another mechanism is go to the RD or NCLT and get the offense compounded.
Okay, for the benefit
Amit like to add something.
Yeah.
So I would just supplement to what Ankit has briefly summed up, just to give a perspective to all the participants, why this adjudication is now on the focus. Because what has happened, if I can go back into the history, I'll take a 2 minutes time to just explain the concept. What has happened under the 1956 law, all the offenses were criminal in nature. Under whatever provision any non-compliance was done, it was punishable with a criminal prosecution. Under 2013, first time government brought a difference between the word used as a fine and the penalty. Under 56 law, it was used interchangeably all across. So first time government brought the concept of civil adjudication by way of introduction of section 454 in the Companies Act 2013. Idea was that government was very well knowing that in last 50-60 years while implementing the Companies Act 1956, they have struggled in enforcement of the provisions because the punishment was so very cumbersome. It takes years to conclude the proceedings before the court, that is the criminal court. whether it is a magistrate or whatever level of court it may be, but the offense takes a trial before the court, and then only the punishment can be given. When Companies Act was being conceived, the idea was there that we will have the adjudication mechanism for the smaller offense, for which the punishment can be adjudicated by the adjudicating officer sitting at the registrar of company office, and he would be able to decide whether to levy any penalty or not, and to what amount the penalty can be levied. This provision was extended by way of Companies Amendment Act 2017, and later on recently by Companies Amendment Act 2020 as well. So 16 offenses in first phase and 26 offenses in the second phase have now been decriminalized. So on one hand, we may have a happier faces that now no longer I would be subjected to imprisonment. I would be subjected to adjudication. But one caution is there that we all must understand. Now government is having an easy option for going for prosecution. You would be facing lot many non-compliance prosecution as compared to what had happened in the last 50 years, because the process was cumbersome. Now the process is easy. That is one reason why government is now moving towards adjudication in as many provisions as possible. And I can say that in times to come, in the next lot, only and only the fraud related offenses, that is 447, 448 and 212 and few other sections, those will remain. Otherwise everything will be subjected to adjudication. It has got certain merits also, it has got certain demerits also. Now the question that was posed by Pawan sir, how it is different from compounding, and what are the significant changes that the government has done or is trying to do. See, compounding was required in case of criminal offense. Why compounding was required? Because if I have done an offense for which I could be put behind the bars. So I was saying that, my lord, I have done the offense good. I have complied the law of the land as on date. Now you don't put me behind the bar. I am ready to pay the cost, whatever you want. Now, so the court was, or the authority was levying the nominal cost and allowing me to compound the offense. So that was a principle. Now in case of adjudication, when there is no concept of putting you behind the bar, so for what matter I am going for compounding? Compounding and adjudication in case of civil wrong becomes the synonym. There is no distinction, because your amount of penalty will remain same whether you go for adjudication today or you go for adjudication maybe 5 years later. It does not matter. If your offense has been rectified, if your offense is not continuing one, then it would have no difference. That is why the concept of compounding does not apply to the civil offenses. That is what I just wanted to sum up. We can discuss further.
Okay.
I just wanted to, if time permits, add what relief corporates have got, with this mechanism, and I'll completely supplement what Ankit and Amit have said. If you say, I'll just give you some background, what problems industry was facing. If you see, there were various sections where there was cross reference to 403, in respect of which we are saying, even if you have delayed filing of a form, you could have filed it within 270 days, which we call a Ganga Snan of 270 days was available. What did the amendment do? All cross reference, whether it is section 89, 92, 117, 121, 137, 157, all cross reference to 403 was removed. And as a case of which, what corporates were told, even 1 day delay in a form, even erroneously, you will have to go for continuation of delay. And the process for continuation, it was also quite tedious, CG1 to be filed, and by the time you take board resolutions. And what was more, which is still there on the record, which is there in the statute, what was more frightening was, while we talked about 403, one provision which talks about if you don't do annual return and annual account, there is a different fine, and for others there is different. But the key was 403(2), which was really frightening, which they said that irrespective of paying additional fees, the company and the officers will still be liable for penalty or punishment. And that was creating reasonable amount of scare of saying even a technical offenses made by a CS or a practicing CS would get you into trouble. And from there, if you say thereafter started the decriminalization, thereafter it started in-house adjudication mechanisms. So all these were to address that problem. So if you really ask me, first, there was a creation of problem of saying, even if there is a technical default, I am going to be behind you. And where thereafter, based on representations, etc., today they've said, I am going to convert fines into penalties. I'm going to give a different view for technical offenses. We are not going to ask for directors to come be present before the ROC, RDs, along with others. You can sit in your own home, do an in-house mechanism. According to me, it's really a huge relief for industry.
Okay. Okay. So, Madan, you were, yeah.
I have certain suggestions. Number one, that principles of natural justice should be followed by the adjudicating authority in letter and spirit. That is number one. Number two, there should be some discretion to be given to the adjudicating authority. As Amit said, that this is going to be a fixed amount of penalty, say a penalty of rupees 2 lakhs. It should be penalty up to rupees 2 lakhs. And third is, in case of compounding of offences, National Company Law Appellate Tribunal laid down certain parameters for the NCLT benches for compounding of offences and levying or calculating the compounding fees. Similarly, here in case of adjudication of offences also, some parameters should be laid down and along with the discretionary powers given to the adjudicating authority.
Okay.
Mens rea should be or should always be kept in mind while levying the penalties.
Okay. So,
just to add what Madan sir has mentioned, the rules made regarding the adjudication, rule 311 proviso, is a culprit actually, because that takes away the power of our adjudicating authority to exercise his discretion. 311 provides the discretion. That rule provides that the adjudicating authority will have a regard to size of the company, capital of the company, turnover of the company, profit of the company. But 311 proviso takes away everything. That is where the problem is arising. I think his point is very valid. It should be considered. And of late, I have observed in majority of the changes where the government is bringing, they are removing the word up to. That means discretion is taken away. Wherever the penalty is getting prescribed, it is fixed amount of penalty. The up to amount, because in a way government is doing right, because they are taking a discretion at the bureaucratic level. They want to give a right principle that if you delay of 1 day, then it would be this amount of penalty, right? That way. So they want to take away the discretion, basically.
Now I have received certain comments of people. Now the point is, there is a big confusion in corporate world regarding the word as compared to other law. So I'm just confined to the company law. So to give a simple meaning to everyone, if there is any word mentioned a penalty, it is a compoundable. If there is a word which is mentioned fine, it is, though it is compoundable in different way, but it is a higher thing. Penalty is a lower, which it can be settled with adjudication process. Okay. And then we have a cognizable and non-cognizable. Then we have a compounded, non-compoundable. So I'm just showing you one chart. And this particular chart, if you can understand, it will be very simplified. Word penalty. Penalty mean in-house adjudication by registrar of companies, wherever word penalty is coming in a single word. But wherever is fine is coming, fine, only fine, fine or imprisonment, fine and imprisonment. These are the three words you will find in the Companies Act. So if there is a word fine, fine or imprisonment, this is a compoundable. And there is a two agencies. If amount is up to 25 lakh, then compounded by RD. If amount is more than 25 lakh, compoundable by NCLT. Now, if there is a word called fine and imprisonment, then it is non-compoundable and it had to adjudicate only by the court. If there is a, now these all are these are the non-cognizable Now come to this point, particular point, cognizable offense. This is under section 447 fraud, where court and SFIO is doing investigation and doing this. If you can take this chart, take a photograph of this chart, entire company law, this penalty, fine, imprisonment, who will do whatever this, who is cognizant, what is not cognizant, that is a clear-cut message you can understand and you can differentiate. So any comments on this particular point, Madan, Amit? So,
I think this is a perfect layout that has been created. Only point, as you have already distinguished, is regarding the cognizable offense. This cognizable offense was there in the 56th law also. There was one provision regarding the deposit, 58A. The offense under 58A was cognizable. That means the arrest can be made even without warrant. Now, how the distinction has been made in respect of 447, section 212(6) says that if your offense is under 447, that is, it is a cognizable offense, your bail application would not be heard unless and until the prosecutor counsel is present, or you have given the court has got convinced with your option. So that is the only difference with regard to the cognizable offense under the 2013 and with regard to the previous. Otherwise, I think rest all point are perfectly explained.
okay, any other comments of anybody? This chart, you can take a photograph and a screenshot.
So my request is you circulate it to all the participants, so we can take a printout and put it on our pin board.
Okay, I will send. We will send this particular chart. Okay. Now, Vivek, please remove this chart. Okay. Now, my one question on this particular issue: if there is a old cases, now they are saying this is the future. Now there are some old cases, and the law is silent. So what will happen? The old cases, it will continue, because the purpose of this law is to give a ease to the corporate world. What is your anybody? Madan, can you just Amit?
See, this is a very big debate that is going on in-house in the ministry itself. If I can give a background, when on 2nd of November 2018, the first time the phase of decriminalization started. And that was just immediately after the bombarding of strike-off notices and the strike-off of the companies after demonetization. So the entire exercise has a background, and background started from demonetization, belief of a government or misbelief of a government on certain issues, striking off of the companies, and then the action that the government wanted to take against these companies who were defaulters. Then government realized that it is not possible because it's a very long drawn process. We should decriminalize all these things. Now, if let's say non-filing of a balance sheet was a criminal offense prior to 2/11/2018, that means for the year 2017, if I don't have filed a balance sheet, no civil adjudication was possible. Only and only a matter can be filed before the special court of competent jurisdiction, and the trial can take place. Only then the penalty, only then the fine or imprisonment can be levied. Now, with effect from 2nd of November 2018, the offense got decriminalized. That is, now it is punishable with penalty. Only civil adjudication can take place. Now, $1 million question is, if I have not filed the balance sheet for 2017, at the time of doing the offense was criminal. Can I be subjected to a civil adjudication? My view is that because civil adjudication is a beneficial provision for the customer or the corporate, so definitely it can be applied. Now, question is then in that case, at what rate the penalty would be levied? Because penalty is as per 2/11/2018. Previous, the punishment was given, which was fine. That was not penalty. Although in most of the cases, the amount of fine and penalty are same. Although in later part of amendment by 2020, the amount has also been reduced. So there are two legs of question that we should debate. First is where the offense is getting criminal to decriminal. Whether court is having or adjudicating authority has the power to take that offense or not. That is one. And second question is where the amount has been reduced. In those cases, at what point of time penalty should be checked, whether at the time of commission of the offense or at the time of the levy of the penalty. And this question becomes again very pertinent because now government from 1st of April 2021 is expanding the definition of a small company. And under the provisions of 446B, that is with regard to reduced amount of penalty for certain class of companies, that is small company, startup, producer company, and so on. So now if my company will become a small company on 1st of April, and let's say on 10th of April, government wants to prosecute against any such company, whether that company would be entitled to a benefit or not. I have posed
But Amit,
yeah.
It is not an established principle of law that any offense committed at any particular point of time, the penal provisions that are applicable at that point of time will be levied. Even if they are changed in future, I cannot say that I would be subject to the new regime, because the day that the offense was committed or the default was made, we have to look into the penal provisions at that point of time. Why
So
we need to go into a judgment?
Ankit, are you saying, sir, just a minute. Ankit, are you saying
please go ahead.
The offenses which were committed in 2015, 16, 17
Yes.
or prior to 2018, only criminal prosecution can be done?
Yes, they will be, because at that point of time, that was the law.
So
Every
that is
offense, the date has to be when it was committed.
Ankit, okay. We have
Just
to.
1 minute, Pawan. Can I take 1 minute only?
Yeah, 1 minute.
See, according to me, always the law on date, it will prevail. So if the action has already been initiated against the offender, it will continue, despite the fact there is a change in the law. If the action has not been initiated, then the law prevails as on the date on which you are going to initiate the action. You have to go as per the prevailing law only. You cannot go as per the earlier law. That is what my view is.
But sir, tribunal, while compounding a lot of matters, have compounded the penal provisions that were there at the time of the default.
56 Act. Ankit, you are
Maybe
right.
GP is the best person. Let us see.
Friends, there are three.
But Pawan, I think if ASR is joining later, we can also put on hold some of this adjudication if he's joining later, and we could love to have his views.
That's why I'm requesting all that because CSR, there are so many questions we have to answer. So I'm just changing this particular thing. Now, Narayan, the CSR recent amendment on CSR spending, treatment of unspent amount, set of excess amount of spending, administrative overhead, CSR committee, agency impact assessment, capital assets. So these are all changes has taken place. I just want to take your quick view, then I will ask questions which people have asked.
So I think a huge number of changes have taken place in CSR. And before I start, just wanted to make a mention. It's really new and evolving. And in fact, we may have differences even within us also, because the way I read it and the way others read it may also be different. And hence I'm going to ask each and everybody participant to ensure that please apply it specific to your case. Now coming to the major amendments which you are talking, yes, the changes have been huge. It is no longer CSR, it is compulsory CSR, because if you don't, it's no longer comply or explain. You will have to ensure that if it is unspent, you get into a penalty regime. New concepts are there, whether it is in terms of changes which you have to do to your CSR policy, changes which you have to do to your annual action plan, registration which you have to ensure that every registration is in place, whether it is in terms of Companies Act, income tax, 12A, ATG, whole lot of issues. There are certain issues which are going to be specific to law, which is interpretation issue, and there will be issues companies will be facing specifically with regard to the process. For example, a law, as you're aware, today, if you have if you fit into more than the 10 crore threshold, and if you have projects more than 1 crore, you have to do an impact assessment. There are two views coming here, even here, because the fear with a lot of companies were that, specifically IT companies, Pawan, they are going to have their accounts cleared by their board virtually in the first week or within 10 days, that is in April. Are they going, they will be required, they'll just get few days to get into impact assessment, because you'll have to give it to the board as well as go to the annual report. So one view clearly emerging, and I thought even MCA was reasonably clear for giving a clarification when we had approached. They said that this law is applicable from 22nd Jan 2021, and only those projects, because there is a threshold of 1 year, because impact assessment has to be done only after 1 year, that is projects before 1 year. So one view emerging very clear even for impact assessment is start from 22nd Jan 2021. So the first assessment you have to do only in 22nd Jan 2022. Hence, there's no need for worry and no need of you to ensure that in 10 days you have to do everything, because it is still in a churn mode. But I thought this was broadly, but there are many issues, both interpretation as well as in process, which industry is also taking it up with MCA. They're also developing a number of issues which need clarification. But over to you, Pawan. We can start with the Q&A, and then we can, as
Ryan sir, since you talked about this impact assessment,
yeah,
just want to have your view with respect to this 1 crore limit.
Yeah.
Do we need to aggregate, for example, if in any activity during 2 years 1 crore rupees has been spent, for that, will that be eligible for impact assessment, or the 1 crore has to be spent in one particular year?
No, only if your project, because it all depends at the end. What are you terming it as? If you have a project which has got more than 1 crore, it could be anything, whether it is healthcare, it is education. If that project is more than 1 crore, then you will have to do impact.
It is project wise. It is
project wise.
So then we can aggregate.
Yeah. So Pawan, over to you. We can start with the Q&A if any.
Okay. So now my first question is, Sudhakar, Ajin Premji has said CSR should not be mandatory. What is your view on this?
That, right from the beginning, CSR was never mandatory. It was already started with a comply or explain approach. If you are not able to spend the money, you have to explain in your director's report. But over a period of time, the intention of the ministry has completely changed to that extent of imposing even the criminal penalties, imprisonment. That was very surprising. In fact, I remember about 2016, I think, there was a conference at NSE where the Ministry of Corporate Affairs representative was there, and that time several companies have received the show cause notices for not spending the CSR money. Then the MCA representative has been asked this question, that why the show cause notices are being issued. So in a different way, they have projected it as if it is a mandatory provision. Though it was not mandated, but it is a mandatory provision. You have to spend the money. That is what is being expected from you. Now the way it is there, because you have to transfer the money, you have to spend the money and all, it is now we can take it more or less, it is a mandatory provision only. And this is the first time in the world CSR is mandated for the corporates. Nowhere it was there like this.
Okay, now my first question is, if this I'm asking, this question is to Narayan.
Yeah, go ahead.
The company has transferred the CSR contribution to CSR. Whether that will be considered as an amount spent, or will it be considered spent only after receipt of utilization report certification from CSR partner?
So this is a question which is really boggling everybody, because if you see earlier, you had at least Rule 7, which allowed you to give into the corpus of a particular implementing agency. That Rule 7 is also now been deleted. Rule 2 is very watertight in respect of where the CSR can be spent. So when we had raised this question, One answer which we got when we were having some discussion is that when you are giving an amount to an implementing agency, can the company just treat it as spend? Because I can say I have contributed it to the corpus, and we are, as a board, as a committee, the company will monitor those expenses. Or is it that if it is not spent on 31st of March, we have to treat it as unspent at the company's level? If you see 135.5 is very clear. It only talks of the company. It doesn't talk of the implementing agency. Of course, we are also, what I'm saying, cognizant of the fact that in the committee report, which was the CSR committee report, the High Powered Committee did mention that they need to have a clarification that disbursal of funds to implementing agency should not be considered as spending. But my view is, if you read 135.5, it only talks if the company fails to spend. And one answer again, which we got was probably what you can do is, if you have given it to a implementing agency, treat it as a project so that you still have 3 years time. There also an anomaly, because if you treat it as a project, within 30 days anyway I have to transfer it to an unspent amount, correct? Are you saying that I have to take it back from the implementing agency because only I have funds? Because it's the same principle what we apply, Pawan, for dividend. We transfer dividend only if there is amount in the dividend account. Can you transfer it to unspent, correct? But if you don't have an amount, if you've already given it to the implementing agency, how can I treat it as an ongoing project? So this is some clarification which we need. We are already doing it through chambers to MCA to say that just like we had an initial earlier Rule 7, which allowed it to be given it to the corpus, can they confirm or they could clarify a bit, stating very clearly that it is only if the company fails to spend and should not be extended to the implementing agency. I know it could be argued both ways of saying, is it that last day you can just give it and treat it as spend? But this is my broad view.
Okay. So.
Yeah, see that I may slightly differ with Narayan here, that the implementing agency is nothing but my agent. I am the principal. I am supposed to spend the money. If I give it, because you know that if it is not an ongoing project, I am supposed to spend the money within 1 year, whether directly or through my agent, that is the implementing agency. If my implementing agency, I have given the money for whatever the reasons it is, they are not able to spend the money, I am supposed to transfer the money to that unspent account. Now the question comes whether I have to take the money back from my implementing agency or from I will do it from my own funds. That is my headache. It is not the headache of the regulator. That is how I view that.
No, but Sudha, the only point which I would like to humbly submit is, you will be a big company like with Reliance, Mahindra, we will be going through almost dozens of NGOs, dozens of trusts, okay? You would have given money and that particular trust would have received money from N number of companies. If you're saying the requirement of 135 subsection 5 is for the company to transfer it if it's an ongoing project, okay, if the company is not having funds, for some reason, you're not able to even get it from the trust back, because you will be dealing with hundreds of trusts. They would also be dealing with hundreds of companies dealing. It may not be right for you to say that every amount which is unspent by the implementing agency, I will use principal agency. Principal agency in any case will apply. But there are going to be huge issues in terms of making those accounting, and hence we said that it would be better that it is restricted to the company. Of course, there can be mischief placed both ways, Sudhakar. I completely agree with you, but I thought I'll just give you this.
Okay.
Sir, but don't think that the actual responsibility lies on the board to make sure that while they are giving that money to the implementing agency, correct, are they themselves confident that the amount, considering the project size and the budget outlays that have been given, that the amount will be spent? Because I have seen in a lot of cases, the budget outlay from the first day is very clear that the amount would not be able to spend in that particular year. In spite of the fact, companies, in order to avoid this requirement of being called as unspent, tends to transfer the entire amount to those funds or trust so that they can say in their books that they have done the compliance. I think the onus will also lie to some extent on the board to look into these cases, whether the money actually transferred is transferred with an intent to be spent during that particular year.
Okay.
Undoubtedly, Ankit, fully agree.
Okay, no,
Because
no.
the rules also clearly require the board to monitor.
Okay.
Agree,
Okay. Now, friends, 5:10 has taken place, and there are two topics. So, in the exam, we are spending more time on first, second, third question. Now we have to quick. So, my request is we have to give answer, no discussion now. Now, some question, Amit, if partnership is converted into private company in the previous financial year, will CSR provision will be applicable in the next financial year on becoming private company?
So if, let's say, a partnership firm has got converted into a company during the year 1920, and it has got a profit. So for purpose of Companies Act, the date of incorporation would be considered from there. The first year would be starting. So you have to see if in that financial year it has got a profit or it meets the criteria of 135(1). Then in next year you are subjected to 135(5). Otherwise, no.
Okay.
So previous history is not relevant.
Okay. Somebody has given comments, which is good. As far as I see, the CSR has moved from voluntary regime to compulsory compliance. As per recently amended rules, the compliance are listed. Okay. Now,
Not able to hear you, Tom.
He's frozen.
how can or shall impact assessment be required?
Pawan, you have to repeat. You're frozen for about a minute, half a minute.
Okay. But I'm asking this question, Narayan.
Yeah.
If the company has CSR obligation of more than 10 crore and transfer the whole sort of to PM Care, how can or shall impact assessment be required?
So if the amount is given to
PM Cares.
No, so this doesn't apply for amounts which are given to those funds mentioned, including PM CARES Fund. If you recollect, even in last year, around end March, MCA had requested CEOs of many companies where they had said that even because it was a national pandemic, was national, huge disaster, companies were required to support PM CARES Fund. And I think every company went ahead and did that. In fact, there was an appeal even in the MCA website, which clearly made a mention that even because Pawan, they came, the pandemic started virtually showing its colors more in March. And towards end of March, all companies had exhausted the 2% limit. In fact, an appeal was made by MCA to all CEOs to say that please contribute to the PM CARES Fund because it is, and all companies went ahead and do it. And they said that even if there is an excess, you will be getting a set off in the next year. So hence, many of the companies who have contributed to PM CARES Fund today are actually short in the budget for the current year. They would be taking a budget minus that amount which was paid to the PM CARES Fund last year. And hence, we are also have requested MCA to clarify that at least for this, while we understand the Act and rules have come into place from 22nd January 2021. However, because this was a specific contribution asked, we've asked MCA even to clarify that at least for this particular purpose, allow us to do a set off for this year. Otherwise, it will tantamount to double jeopardy. I'll tell you why. Because if companies are short of budget by say that amount which you have spent, that will have to be against transferred to that amount within a period of 6 months. So hence, we thought it will be better if clarification could come from MCA. And of course, I would love to hear Savitri or others if they have a different view.
Okay, now I'm just
on the lighter side, you can't dare to ask any question to PMO, you know.
No. I think every company went ahead and did it because it was a thing which we all wanted to help in the COVID cause, and all companies have got. The only issue was because it came in the dead end of dead end of March, companies had already exhausted that 2%. That's the only thing.
Okay, now friends, I have just modifying the because I was thinking that we will receive less question on new changes. So that's why dividend and deposit we have kept it. But I think there are so many questions are coming for adjudication and the CSR. So first I will finish this, then I will move to other chapter. So I have so many questions. So please be short for your answer. Okay. Now one question is, all companies doing CSR even on their own out of their funds are required to file from CSR 1, Ankit?
No, sir.
Now,
Agree.
okay.
No, I feel it's
Geetika-
required.
Geetika is saying required, 3% saying no. So,
Not required.
Sudhar, what is your judgment?
No, according to me, also it is not required. Only the implementing agencies have to get the file the CSR1 form.
Okay,
The whole purpose or whole the logic is only because if I am directly contributing to a school or anybody, company is anyway regulated by MCA. They are what they are trying to put is, if you see A and D, when they talk about a Section 8 company, trust or a society, those which have to be registered both in the Companies Act by filing CSR1 and getting registration, as well as under 12A and 80G. That does not apply to the company itself.
Yeah, two reasons. One, it is coming from Rule 4.2, and 4.2 refers to the entities referred in 4.1, and entities are in
Absolutely.
A, B, C, D. And second is, if you refer the form CSR1, CSR1 has only these 4 category A, B, C, D. That's it. There is no category of a company.
And I'll try to substantiate why I'm making a mention, why we feel that it is still only not to the company, because if you go through Annexure 2, I'll just see if I can open it. Even if Annexure 2, if you see Annexure 2, just go to clause 8B and go to column 10 and 11. It will first ask you to mention the mode of implementation. You'll ask direct yes or no. If you put yes, there is no requirement for registration. But if you say no, and if it is through an implementant, then only it's asking CSR registration. Just a process point, but I thought this will just substantiate this point clearly to say company no need of CSR1, only implementing agency.
May I?
Yeah.
Yes, Madanji.
Amit said that in 4.2 it is written that every entity covered under sub-rule 1.
Yeah.
And sub-rule 1 says the board shall ensure that the CSR activities are undertaken by the company itself or through ABC. So company itself is also covered there.
No,
Why?
company is not an entity
It
here.
means now we need
It is.
clarification that the company itself shall not be required to register.
No, but Madan, I
I think,
agree,
sir, the form
because it's
itself is
slightly a gray
clear.
area.
The form
We
itself
are-
is clear.
No, I know.
It means form is overtaking the rule. That is what I said in the beginning also.
Sir, that is happening regularly in MCA.
That we need to come out
Okay.
of that.
Just one point on
Yeah,
that
Geetika wants
is,
to.
on the point that Shankarji made, where in the form in column number 10 or 11, there is a
No, Annexure 2,
drop down.
Annexure 2.
Sorry, in the form, there is a drop down where there's an option whether you've done it yourself or through an agency. Now, if we are saying that it was never the intention of the legislature for the company to get registered, it would have never made that option. It could be seen that way also. So anyways, I'll leave it. I think
now we will
clarification will be helpful.
we'll focus on clarification. Now, no, please. There are so many questions. One question we can't stick to on this. Now, Amit, due to accumulated losses, there are no requirement of CSR spent during financial year 1920, 2021. Still, company had spent voluntarily for both the years. Can company set off these excess spent in next the succeeding year?
Yeah, any excess which is over and above the statutory limit of 2%, minimum 2%. So anything, suppose you are spending 2.5%. Now statutory limit is 2% minimum that is required, whether you do voluntarily or whether you do statutorily. You are not required, but you have done. So in succeeding year, you can take only set off only above whatever you are doing above 2%.
So it means if there is a loss and I don't require to do it, and whatever I'm spending, I can carry forward.
No, only in excess to 2%.
No. I have a loss.
But
So
in
as-
case loss, there is no amount of 2%.
So law.
It is zero.
No,
It is
but
negative.
Ankit, one way of saying is if you have a loss, that means entire amount is in excess. Now there's no 2%.
Yes, entire amount is in excess.
Yeah, and I agree.
No, sir, it depends. So maybe in the year 2021, I am having no amount required to be spent, right? That is
Okay.
one. So in that sense, maybe I am whatever I am doing would be subjected to carry forward, right? But maybe I am required, if I calculate the average of 2% of the last 3 years, it is coming to some amount and I'm required to do that much. So over and above whatever
Yes,
I'm
that
doing,
is
that
clear.
That
is clear.
The meaning is clear. Whatever you are required to do it, that is a base limit. If you are spending that above to this,
over and above, yeah,
okay.
over and above carry forward allowed.
Yeah. Now, Madan,
My submission is the law does not say that company has to spend 2%. Law says at least 2%. So if you have spent more than 2%, how can we say that we have spent in excess?
No, because Madan, let me just try to address what you're saying is 135. No, a very important point. Because if you see 135.5, which stipulates spending of at least 2%, okay? But if you go through the proviso, it only says if the company fails to spend such amount, okay? Such amount which is in excess, correct? So the word such has to be read along with the section of saying that at least 2% cannot definitely mean 20, correct? Anything in excess of 2% will be the way to interpret the word such amount, but leaving it to
this
our
is
legal
fine
enumeration.
interpretation. This is fine interpretation. We will discuss this separately. Okay, Kitka, what shall be the treatment of unspent CSR amount of earlier year till 2020?
Sir, I think if you look at the intention of the law, what they're trying to say is if you've parked funds and you which are unspent, you need to transfer them within 30 days. The logic applies to previous year period also. So net, if I have something on March 2021, I will transfer the entire amount by April 30th, 2021. This is obviously subject to others' view and clarification, but this is my own feeling.
Amit Hayana.
So, no, for
No.
previous year, there is a big no because the law was comply or explain. I have in the previous year already explained that why I have not done. Just one caution, if you have created a provision, you just ensure that you are reversing the provision in the current year, it does not carry forward. That's it.
I agree.
I fully agree with Amit.
So
what did you do for deposits which were to be transferred?
Law is
Logic
always
is same.
prospective. Law is never retrospective. Law is always prospective unless until it says that it is applicable retrospective effect. I will always take it with a prospectively.
So the simple meaning is, if there is an unspent amount of last year that was on the comply and spent and
Comply or explain, correct, Pawan?
So if you are not
Correct.
done this, there's no okay. Because
Yeah.
Now if you are doing this, you have to carry forward.
It's only after
Yes.
22nd January 2021.
Okay.
Correct.
Now, a donation to Indian Institute of Science, Bangalore towards R&D and propagation of education. Can this be considered as CSR spending, Sudhakar?
Education, see, the Schedule 7 education is already there, and MCA circular also that it is to be liberally interpreted. So I take it as it will cover under CSR activity.
Agree. Let's go
Okay.
ahead.
Amit, do company need to open separate bank account and transfer CSR money in it if the company does not spend by 31st March and there is no ongoing projects?
There is no ongoing project. In that case, it has to be transferred to the fund within 6 months.
Okay.
Account is not required to be opened.
Yeah,
Okay. So
agree.
within 6 months, and if this is ongoing, then first you have to transfer to the CSR account within 30 days, and then if it is not completed within 3 years, then you have to.
That is only in case of ongoing project.
Yeah, I'm just saying ongoing. I'm
Both
different.
correct, Pawan.
Okay. Now, Ankit, who will be conducting agency for impact assessment?
So there are agencies who does this job, the outlines any specific agencies board have to consider while appointing any agency for impact assessment based on his past credentials.
Okay.
Corporate professionals.
Geetika, with regard to second proviso of section 135(5), if any company has unspent amount for financial year 18-19, 19-20, is it mandatory to transfer that amount to specified fund, schedule 8, or unspent amount of only 2021 is supposed to be transferred?
I thought we should just.
We just, yeah, Geetika, right? We just answered it.
Okay.
Yeah.
Yeah, okay.
Okay. Now, Narayan,
Yeah,
whether contribution to PM Care Funds or PM Relief Fund eligible for CSR activities?
we've already answered this. We should go next.
Okay. Now, the interesting question is whether the company created provision of 3% of the net profit but spent only 2% is statutory required. What will be the treatment for the remaining 1%, whether the company is required to transfer such 1% amount to fund specified schedule 7 in terms of specified section 135 or 5 second proviso?
No,
Not
Pawan,
required.
it's
Not
merely a provision and not a statutory requirement.
This also Shankarji addressed where he said that both the provisos use the word such amount and that such
Yeah.
amount is linked to.
Okay, Madan sir, in case of ongoing project, companies had only 1 month time to deposit the amount to special account, whereas in case of non-ongoing project, the company has 6 months time. What is the rationale behind giving 1 month and 6 months? Why so much gap? It could have been same for both the case, be it 1 month or 6 months.
I think this question needs to be answered to the ministry, not to me.
I can answer.
Yes,
I will answer this question.
I will answer. I will answer.
Because every time we say this is the intention of the legislation and nobody knows the intention of the legislation.
Okay, Sudha, please give.
See, according to me, for ongoing projects, you have already been given sufficient time. 1 + 3, 4 financial years you have been given.
Absolutely, Sudha.
So if you are not able to do that, if you are not able to execute the ongoing project within 30 days, you have to transfer it.
Okay.
As far as the other thing is concerned, that you are not able to spend the money, you transfer it within 6 months. That might be the logic.
No, the question is why 6 months? Why not? That is also again within 1 month of the close of the.
GP, that is because when you have to transfer, what happens, they say you have to transfer it to fund specified in Schedule 7 within a period of 6 months. Then Rule 10 further says that till the time such fund is there, you can transfer it into any fund included in Schedule 7. They are giving you enough time. And I'll tell you, Madan, one more problem which we are going to face. And why the 6 months time? Today, earlier it was only comply or explain. I genuinely felt 10 things I'm doing is covered under the CSR and I've already given it. Tomorrow, say in the next 2 to 3 months, somebody comes and says, actually entry number 20 and 29 does not. Sorry, it is your own product, it is marketing, it is not given. Or you do something else, actually we are treating it as your samples or something. So all I'm saying, there is still time for you to comply. Otherwise, 30 days will be too short for you to comply.
Correct.
Okay, Ankit, who are required to open separate unspent CSR bank account every year?
Sir, companies which are undertaking ongoing project and which have unspent amount for a particular financial year on that ongoing project are required to transfer that within 30 days of the close of financial year.
Yeah, agree.
Okay. Is CSR committee required in case of contribution is less than 50 lakh? Are these provision applicable to 2021? No.
Not required.
Okay. What do you mean by amount spent in CSR if I raise invoice before 31st March or if I pay before 31st March and works are taken in April or subsequent month? Amit.
Indian mind jugaad.
See, spending means actually the money has to be spent out from your books. If you have issued the checks and checks have not been in cash, that's not the problem. That can be in a reconciliation. But intention is that expenditure should be incurred by the company.
And the same answer, Pawan, was given even in the FAQs of MCA, which is also now come into the rules of saying that when you are doing your own samples and giving it, you're not going out of pocket, you're not spending. Hence, you have to actually spend. They were emphasizing on the word spend, if I'm not mistaken, even in that FAQ.
Okay.
And
Geek,
moreover,
I
Pawan,
agree.
let us find the moment some amendment comes, we try to find out loopholes in the amendment, even though the amendment is laudable. We, the professionals, try to do that, and then we blame the promoters and the management that they do something wrong.
Yeah.
Okay, Ritika, donation to Ram Mandir temple is CSR activity?
No.
Wrong question to
Okay.
wrong person.
No. I can explain.
Yeah.
Right question to the right person.
Can
Yeah.
be
Let the
covered.
person from Lucknow explain, Geetika, please.
Yeah. So if you see the para 4 of Schedule 7, protection of national heritage is covered in the para 4. And if you see the ATG exemption of Ram Mandir Trust, it says it is a it is a monument of national importance and national heritage status has been given.
I think, Amit, it is religious importance, and it says restoration of. Yes, it is places of religious importance. It says places of religious importance and restoration. So Ram Mandir is being restored.
It does not exist that you are restoring it.
No,
Yeah, so that is why you are restoring it.
I'm saying, let's say if you are maintaining or restoring any such building, I'm not going into the debate whether it is there or not, but there are trusts who are maintaining these type of national heritages. If yes, then that entity would be qualified.
That's
Yeah, but
different.
it
But
doesn't
here,
use
if you're
the word
creating something, it's different.
maintenance.
Amit,
It uses
Amit,
restoration
just for the
of
benefit-
religious importance.
I think
Ram
For the
Mandir is
benefit
not
of the
of national heritage. It is of
I'm
religious
just
importance.
1 minute, Pawan. I'm just reading that particular thing. Schedule 7 says protection of national heritage. See, that means what? Protection of national heritage means if it is already there and you are going to protect that. In case of Ram Mandir, it is being constructed.
Sir, it
No,
will
no,
fall
no,
under
no, no, no.
Sir, it will
Sir,
fall
it is
under restoration of
already there.
places
It is
of
already there.
religious importance.
Okay,
It will fall under restoration of places of religious importance.
I think we will have a separate topic on Ram Mandir.
My simple submission is you are giving this amount to a trust. Let's see the object of the trust and then decide. That's all.
Okay, I'm stopping this.
Sir, the object is in the question.
Yeah.
That's
Okay.
all.
So okay, for filing CSR, please clarify.
No, nothing is clarified. Your voice.
Sir,
was
you
lagging.
need to repeat the question.
For filing CSR1, whether sub-registrar is required, please clarify.
Whether sub-registrar, it is with registrar of
No,
MCA 21.
No. I think the question is somebody is asking if trust is required to be registered with the sub-registrar for filing CSR1.
Yes,
So
yes.
answer depends on the state in which the trust is created. Let's say it is created in the state of UP. In UP, we are registering the trust with the sub-registrar. In Bombay, it is registered with charity commissioner. So it depends in which state you are. Those state specific law would be prevailing for registration of the trust.
But unregistered trust in any
Two registration. One is the registration of the entity, another is registration for the purpose of CSR with NCA.
Sir, 80J 12A, you cannot get a trust registered under unless the trust itself is registered.
So that is what
an unlisted trust in any way cannot, because they will not get the registration under 80G and 12A.
Narayan Shah can confirm, because in Bombay there is a separate charity law. And in that case, the charity commissioner is also there.
Whatever the law it may be, but it has to be registered. Whatever the law it may be.
Okay, some very interesting question are pending. So I just, as per definition provided in company's CSR policy, amendment rule 2021, timeline for ongoing project is not exceeding 3 years. What if the timeline of company project is more than 3 years and the same was earlier approved by the board? Narayan and Sudha.
So, see, this, 1 minute, I'll just open that relevant rule. 1 sec. Yeah, so, see, the underlying intention to spend 2% when we are talking about 3 years ongoing, was to spend 2% every year. An ongoing project is an exception to this rule, Pawan, and not and has to be done very judiciously. If you see 211 ongoing project, it's just in front of me, means a multi-year project in fulfillment of having timelines not exceeding 3 years. So in terms of definition of 211, project cannot or shall not stretch beyond 3 years max, because you are excluding the year of commencement. You can have a leeway of 3+1. So here there could be two ways of interpreting, and indeed there are two schools of thought. One which says that if the ongoing project itself is more than the threshold of 3 years, it does not even qualify per se for an ongoing project, and the entire unspent amount will have to be transferred within a period of 6 months because you do not qualify. On the other hand, the second school of thought is it's fine if you have even beyond 3 years, only the unspent amount in excess of 3 years shall be transferred. This is something I thought needs to have specific clarity. We are again through chambers raising it to the ministry.
Okay. So I'm just shifting my topic to adjudication of penalty. Some 3 questions have come. Amit, whether one can go to adjudication suo motu?
See, in law, there is no provision. However, we have seen the practical scenarios before many ROCs filing the application suo motu and those applications being considered. Although in law, there is no provision. As we can go for compounding suo motu, there is no provision for going for adjudication suo motu.
Okay.
As you said, ROCs are considering suo motu application.
Yeah, ROCs are considering Bangalore and Mumbai. I have the...
Even Delhi is considering.
They should consider, because suo motu application is removing their burden for future, and there will be good compliance regime will be there. Madan sir, when the penalty has been crystallized to fixed amount, is there any need for adjudication?
I actually like this question, and I just forgot the name. I read this question in the Q&A. But I tell you, this is the regarding amount of penalty. But before that, it has to be adjudicated by the adjudicating authority whether the offense has been committed or not. For that purpose, we need adjudicating authority. Not only for the quantum, but for the determining whether the offense has been committed or not. Has there been any violation or not?
Okay.
And secondly, Pamanji, if you allow me, I would like to revisit one particular issue which was being discussed earlier, that if an offense has happened at the point of time when there was a fine or imprisonment, now that has been replaced with the word penalty, can this offense come within the jurisdiction of this penalty at this point of time? My humble submission is that I am reminded of the 2nd March 2020 circular by Ministry of Corporate Affairs regarding independent directors and non-executive directors, where the circular said that no adjudicating authority shall initiate prosecution proceedings unless the adjudicating authority has complete evidence with it against that particular director and with the prior permission of the regional director to initiate this prosecution proceedings. And then the circular further said that this SOP shall apply to the existing proceedings also. It means the government itself has given a leeway. With the objective of ease of doing business, the government has said that yes, existing proceedings will also be covered within this ambit. If that is so, why can't the earlier offenses can be brought within the ambit of this penalty? And second, even if it is not so, Rule 11 NCLT rules is very clear, where NCLT is having ample powers. And at the time of levying the fine, NCLT may say no fine, or NCLT may remand back the matter to the adjudicating authority for levying the penalties.
Okay.
No, but NCLT will not be involved, na, sir, in these cases.
No, if the fines are there and compounding is there and all that, and in case of fines, I agree. In case of fine, matter will go to special court.
Correct. And in case of adjudication, the matter will be remaining with the ROC and RD. That's it.
ROC only, right. But I think court has also got ample power under section 151 of CPC. There also they can remand back the matter to adjudication.
Now, one question, Ankit. Can penalty-related provision be compounded with RD or NCLT instead of adjudication process of ROC?
No, sir. Only fine-related offenses can be compounded.
Okay.
Yes.
One question which I'm asking Geetika, that was an unanswered question on this listed company. If a public company issued listed CCDs, when will it become listed? On date
That was my question.
Yeah, your question I'm asking you itself.
Oh my God.
Date of issue of CCD or on date of conversion into equity. So first your question, then other people will So what is your interpretation?
I think the date of issue.
Okay, Geetika, here it is analysts are not allowed to ask their question.
Date of listing, not date of issue, date of listing.
Okay.
Listed CCDs.
Yeah, yes, the date and instrument
Well,
list.
very different view. Sudha, Narayan.
No,
Pawan,
what
I'll
she
have to
says is
log off
correct.
for some because I'm already getting calls for, was 5:40. I had a meeting. I'll have to log off.
We are closing, right? We are closing.
Yeah.
Okay. So this is my last question, which I'm asking. So any different view what Geetika has given? Date of
No,
issue.
sir.
What Geetika says, I agree with her. It is the date of listing of the CCDs or CCPS.
Okay.
That will be the date.
Okay.
And more Mumbai club can't afford to oppose Geetika, you know.
Okay. Okay. So friends, I think we have discussed and we have given all answer of these 4 new amendments listed, the LLP, adjudication, and recent amendment of CSR. I was expecting that we will not receive much questions, so that's why we have added 2 old topics which has always issues. This 2 topics we will take up separately some other day when we will have the general questions on all subjects. Some of the members, participant has sent me some questions which are not connected to all 6 topics. We will take up these questions in some other part. I thank everybody for this coming for this program in large number. I think today more than 550 people have joined and they have raised 84 questions today. And then there are 50 questions we have received earlier. Some common question I have removed and we have worked out. Yeah, Sudhakar.
Yeah, only thing is that I want to take this opportunity to once again to convey our sincere thanks to corporate professionals, because whenever we participate in these webinars, we always go back with a definite value addition. And it is our real pleasure and look forward to participate more such webinars. Thank you.
Okay, so my request to all the participants that whatever topic you want to you can suggest us, whatever topic, whatever questions you have, you can give it to us, and we will definitely organize program of your interest. Next program we are organizing on Gift City, the opportunity in Gift City, and both the ED of director of Gift City will participate. And I will request all of you that this is one of the new opportunity for all the corporate world in India. You will have foreign jurisdiction in India. While sitting in India, you can take all advantage of export process, doing trading from Indian soil, just like you are trading outside India, and so many advantage they are providing. So the next program
Will it be a webinar or seminar at Gift City?
This will be a web. Always we will be having a webinar, and we will try to continue the webinar in the same manner of 1.5 hours question answer topics and same process. So I thank all the participants, and my special thanks to Geetika, Amit, Sudhakar, Madan sir, Ankit, Narayan Shankar, Savitri and KSR is not able to join, but I thank all of you. You have given all the answers very promptly and very effectively. So thank you everyone for participating.
Thank you.
Thank you, sir. Thank you, everyone.
Good evening, everybody. Had a great day. Have your mask on.
Yeah.